Justice with Judge Mablean will be life, because in everything we do, it involves the law.
You came to court to testify about what you heard, what you saw, and what you know.
She's fair.
I don't have a hearing problem. This ear works good. This one works even better.
She's firm.
I'm not responsible for that ticket, and I'm not going to pay for it.
Who says you're not going to pay for it? I make that decision, not you.
She's honest.
What you have to say?
All I have to
Nothing.
say.
This is Justice with Judge Mablean. Belinda Garmond is suing Randall Tompkins in the amount of $500. Ms. Garmond claims Mr. Tompkins confiscated her son's hoverboard, and when they received it back, the hoverboard was damaged. Mr. Tompkins claims the hoverboard was already broken when he confiscated it.
In the matter of Belinda Garmond versus Randall Tompkins, I understand you're suing him for the cost of your son's hoverboard, a claim for $500.
Yes, that's correct.
Tell me what happened.
Well, Your Honor, if I could just give you a little bit of background about my son. My son Timothy, who rides the hoverboard, he's 13 years old, and he's going into 8th grade. And when he finished 7th grade, we told him if he got good grades, all A's, that we would buy him a hoverboard. So that's what we did. We bought him the hoverboard, and he's been so happy riding that board all summer. Gotten him out of, in front of the TV instead of watching the video games. And next thing you know, a couple weeks ago, I got a call while I was at work. And he was very upset, and he called me and he said that Mr. Tompkins took his hoverboard from him. And I scolded him because, he must have done something. Why did you scold him? I scolded him because he must have done something for Mr. Tompkins to take that board away.
Why do you say that?
Well, I was at work.
Who is Mr. Tompkins in relation to your son, and how does what right would he have to take your child's hoverboard?
Your Honor, I'm a security guard in the community which Ms. Garmond lives in. I've been there about 5 years. She and her family moved in about 3 years ago. After they moved in, we instituted a rule.
Is this an HOA?
It's a HOA, yes, ma'am.
Oh, one of those developments, huh?
Mm-hmm. Your Honor, we instituted a rule, an amendment in our contract, which is under Section 11 here. Is this... You want to.
So you instituted a new rule after she moved in?
After she moved in, banning hazardous devices, which outlines hoverboards.
Coincidentally, Your Honor, it was right when we bought the hoverboard for our son that the new rule was instituted.
Your Honor.
Wait a minute. It was instituted after you bought the hoverboard,
yes,
or before?
Just after we bought the hoverboard.
Let me see the new rule. So banning dangerous vehicles, you say? I mean, dangerous equipment of whatever?
Yes, ma'am. Section 11, it's banning hazardous devices.
So your son called you. He's all upset saying Mr. Tompkins has taken his hoverboard, yes, and you figured he must have done something wrong. So why you figured he'd done something wrong?
Because he's not perfect. I mean, he's my son, but he's a good boy.
So in other words, that rule was in effect.
The rule was in effect, and he knew the rule. When the rule was passed, we explained to him that he was no longer going to be able to ride his board in the HOA neighborhood, but that he could ride it outside the neighborhood.
So
and he understood the
when
rule.
You say neighborhood, within the HOA perimeters?
Yes.
So any of the homes within that perimeter?
Yes, but he could ride it outside the neighborhood, outside the HOA, and he understood that.
So how? If you're on a whole block, and usually it's a section with about 10 or 15 houses and sidewalk. Was it a cul-de-sac?
It is a gated community.
It's gated,
it's gated.
Right? So he would have to go outside the gate.
Correct. And so that's where he was headed on the day that the alleged incident occurred.
Your son said he was outside the gate.
He was outside the gate.
Okay. And of course, you must say that he was inside the gate.
Your Honor, he was inside the gate. We got complaints from various residents of the community about him riding it around, being erratic.
I do have some written testimony, a statement of fact from a friend of mine, Nancy. She lives in the neighborhood, and she observed the whole incident. And so I have it here. I can.
Why isn't she here? Or your son?
She couldn't make it tonight.
What about your son? He knows what he was doing better than anybody.
Well, my son's,
he's the best witness.
My son's in school right now, Your Honor. But my friend Nancy observed the whole thing, and she said what happened is my son actually was racing up on his hoverboard. I don't want you to tell me what she said that she saw since you gave me her statement. Now, Mr. Tompkins, you tell me your version since you were the only other first-hand person. Whatever.
Yes, Your Honor. The day of the incident, the defendant's son, the plaintiff's son, was trying to leave the community and was speeding his hoverboard towards the gate. There was an elderly woman who was a resident in the community with her cane. I thought he was making a beeline right for her. So I intercepted him. I took the hoverboard. I instituted the fine that comes with riding a hoverboard, which is a violation of the new policy. And I told him to contact his mother, have her pay the fine, and he can get his hoverboard back.
How much is the fine?
$200, Your Honor, which we paid. We paid the $200.
Okay, so why did you pay the fine if he was riding outside?
Because I said he's not perfect. I mean, I know
No,
that...
no. This has nothing to do with perfect. This has to do with, did he violate the HOA rules or did he not? We're
Well-
not talking perfection. We're talking violation.
Your Honor, I paid the fine. That means that I
So you
acknowledge what
admit that he
Mr.
violated the rules?
It's possible.
You paid $200 because it's possible. Come on, lady, just admit. My son probably was doing what he wasn't supposed to do.
My son always follows the rules, and he's a straight A
are you serious?
student.
Your
He's a
son
straight...
always follows the rules? You really believe that? You sound like a fish. What child always follows the rules?
Your Honor, respectfully, this isn't about the fine. I paid the fine. It's about
You
the
know what?
$500.
If I say it's about the fine, what I'm asking you now, then that's what it's about.
Coming up on Justice with Judge Mablean.
It's about Mr. Tompkins and the fact that he broke my son's board while it was in his possession.
You know what? You keep telling me what it's about. That's the issue, but you have to prove it.
And later,
I had discovered that he had actually been performing our song that we wrote together, which wasn't his to record.
Justice with Judge Mablean. If you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. You're watching Justice with Judge Mablean. We're back with the case of Belinda Garmon, who is suing Randall Tompkins for property damage.
I'm asking you a question and you say yes, he violated, but you said possibly. I'm just trying to get you as a parent to understand that children are not perfect, as you keep saying, which none of us are, and sometimes we violate the rules. Okay, he violated the rule. If you don't admit it, he'll never admit it. So you have to learn to accept responsibility for your misconduct.
Well,
he violated the rules, you paid the fine.
He might have violated the
Oh, hush. So you go, what did you do at the hoverboard when you picked it up?
Your Honor, I took the hoverboard and I put it in my security booth and locked it because by the time she was able to come, it was after office hours.
Why would you put it in your security booth as opposed to a storage facility or a closet or a locked facility? Because your security booth means that the next person who comes, when you get off work, that hoverboard is there. You're not the only one who works there, are you?
I'm not, Your Honor.
It's a
but
24-hour security, isn't it?
It is, but we are the
Okay.
only ones who have access to the booth. We have keys to
You
the
and
booth.
other security people, right?
Yes, Your Honor, but we
Okay.
have a specific box located underneath our desk for lost and found items and also items that we have confiscated. I put it right in
And one of those persons could go riding on it while you at home.
if it happened, it would be another security officer. I did not
That's
do it
what I
myself.
just said. One of them could have gone riding on it while you was at home.
That could have happened, Your Honor.
Because it wasn't secure. And see, that's what I'm saying. You gave me this woman's testimony, and all she's saying is what he said, that he took the thing. But it has no validity. Your issue is not him taking it. Your issue is him breaking it.
That's correct, Your Honor.
And so this testimony doesn't amount to a hill of beans.
Well-
Because that's the issue. You keep missing the issue. You're telling me him taking it is not the issue, yet you bring me testimony all about him taking it.
Well, I was trying to show you that my son's a good boy.
Oh, boy. I don't make decisions on whether people are good or bad. I'm not making a judgment on whether your son is good or bad. The question is, did this man, Mr. Tompkins, or any person under the control and the authority of the HOA break your son's hoverboard? Isn't that the claim?
Well, yes, Your Honor. that
Okay,
is
so
the claim.
what happened to the hoverboard when you got it back? What did you observe?
Okay, so I went there before 5 o'clock. I had to leave work early, and I got my son, and we were there at the
We got it that you didn't get there in time.
I was there on time that day because I came twice. The first day I came after hours, and Mr. Tompkins told me I had to come during business hours to pay my fine. So I came the next day with my son, and we brought a $200 check, and I told my son, you need to apologize to Mr. Tompkins, which he did.
Okay.
Okay, so then he goes and he gets the board and he gives it to my son, and it doesn't turn on. And Mr. Tompkins said, well, maybe the battery just needs to be charged. And I said to my son, it's all right, we'll try later. So we took it back home. He tried that night. It would not work. That board is damaged
Okay,
beyond.
and so when it didn't turn on and it didn't work, did you take it somewhere to figure out what was wrong with it?
We did. Then that weekend,
Now,
we took
where's
it back
that
to
report?
I didn't bring that report with
Oh,
me.
that's
but
so smart. So you took it somewhere to figure out what was wrong with it. The issue is that he broke it, according to you, but now you don't have evidence to show me that it was broken, number one, and what the damage was, number two.
Well,
Where's evidence to show me that it was broken?
Your Honor, I took it to the store. The store owner told
Where
me...
is the evidence to show me it was broken?
I just have the board, Your Honor. I don't have any written statement from the store owner. But the store owner
Where's
said...
the board?
The store owner...
Where's the board?
The board's at home in our garage.
Wow, you're so prepared.
Your Honor, this isn't about... It's not about me or my son. It's about Mr. Tompkins and the fact that he broke my son's board while it was in his possession.
You know what? You keep telling me what it's about. That's the issue, but you have to prove it.
Well,
So that's what it's about, proof.
I can prove to you that security
Wait,
shed.
prove it to me. Prove it to me that he broke it.
Everybody in the neighborhood knows that security shed is hot. It's full of windows. It's not insulated. So theoretically, it is possible that even
But
if
this was
nobody,
overnight.
Exactly. But even if nobody touched that board, the board could have overheated because the store owner told me the
Who
battery.
said it overheated?
The store owner said the battery had
Where's
overheated.
the statement from the store owner? I keep allowing too much hearsay evidence from you. I can't give it all hearsay.
Well, nonetheless, we gave the board to Mr. Tonkin and it was working. When we got it back, it wasn't working.
Where's my proof?
I have a broken board, Your Honor. That's the proof.
Okay, where is it? So I know it's broken. My problem with you, Ms. Garment, is you have no evidence to support your claim. None whatsoever. Board was in good shape when I gave it back. Board was broken when I received it. Neither of you has evidence that it was in good shape, bad shape. But the duty is on you as the plaintiff to prove your case by a preponderance of the evidence that the board no longer works. You have not done that. Judgment for the defendant.
Judge Mablean has ruled in favor of the defendant. The plaintiff's claim has been denied.
You were responsible for that hoverboard when it was in your possession. I'm an honest woman, and I'm just sorry the judge didn't see that.
When it comes down to it, your son violated a community policy. I'm just trying to keep my community safe.
Coming up.
I had discovered that he had actually been performing our song that we wrote together, which wasn't his to record.
Justice with Judge Mablean. You're watching Justice with Judge Mablean. Natalie Jackson is suing her ex-boyfriend, Nathan Lucas, in the amount of $25,000. Ms. Jackson claims Mr. Lucas stole her song. Mr. Lucas claims he never agreed to give the plaintiff the song.
This is a matter of Natalie Jackson versus Nathan Lucas. You're suing him for $25,000. You said that he has stolen your song.
Yes.
That you wrote and has someone else about to perform it, and you want your money for it.
That is correct, Your Honor.
Okay, tell me about it.
We met about 3 years ago at a local pub. I'm a singer, songwriter. I've just been playing around a couple different places around town, and he introduced himself to me and invited me into his record label if I had signed a contract with him for a 5 years for 3 albums. And after that, we produced our first album together. Things were going great, and we spent a lot of time together. Things started to blossom. We kind of built a relationship over time. And eventually, about 2.5 years ago, I guess you would say in the throes of passion, we wrote a song together, a personal song. It was very emotional. And we were going to debut that later on when we felt the time was right. But after that had happened, I actually set out another single that hadn't really done so well, and after that, he kind of just disappeared from the face of the earth. So I looked him up, I found out where he was, and when I found him in the studio, I had discovered that he had actually been performing our song that we wrote together.
What's the name of that song?
Two Flames.
Two Flames.
Yes.
Okay.
He was actually recording that with another artist, which wasn't his to record. So I'm here just to claim
So
my
has
song
he
as my own.
recorded it?
I guess
He's shaking his
so.
head. Yes, you've recorded
Yes,
it?
yes,
The
Your
song
Honor.
been released and recorded?
It has not been released.
But it has
recorded.
been recorded?
Yes,
By another artist?
that is
Artist.
correct. Yes.
Okay. So what do you have to say about all this?
Most of what she's saying is true. We wrote this song together. She was with me at my beach house. We had spent a great day together, a better night together, and I got up and I actually left the room and I went to my piano and I sat down and I had a song that I'd been kind of kicking around in my head. And I sat down at the piano, I started working on it musically. She came up behind me and she, liked what I was doing and she started, putting lyrics to it. And, we finished this song. It was a great song.
So she put lyrics to it?
She did put lyrics
I
to
wrote
it,
all the
yes.
lyrics.
Okay.
Coming up,
The contract that she signed clearly states that any of the music that she writes during this period is owned by the record company.
you're watching Justice with Judge Mablean. We're back with the case of Natalie Jackson, who is suing Nathan Lucas for $25,000.
So this song is co-written by the two of you.
Yes,
so
that's
therefore
correct.
she's entitled and has some rights to it.
Yes, she does have rights to the
Okay,
song.
so why are you now recording it with someone else?
Well, she has rights. Any money that the song makes, she will get a percentage of
But
that money.
I wrote the
That's-
song for myself.
But
It was between
there's
us.
Hold on a second.
the contract that she signed clearly states that any of the music that she writes during this period is owned by the record company.
One
Let me
thing-
see what this contract says.
One thing, when I confronted him about it, he said that the contract, he owns the rights.
Right.
I looked it up, and it is true that he does own the rights to any of the work that I recorded previously for him, but this song was never recorded in the studio, so he doesn't have any rights to it.
The reason he has a right to the song now is because it wasn't recorded, but it was co-written and produced by the two of you.
And, Your Honor, you'll see...
So that's why he would have a right to it as well. You both have equal rights, 50-50. So it doesn't mean another artist can sing it, and when another artist sings it, you have royalty rights. 50-50. The problem you're going to have is tracking your royalties.
I think we came to a conclusion I would be the performer of that
was
original
never agreed.
piece.
That's not true.
He may well have said that verbally, but he knew what he said. It didn't amount to a hill of beans.
Your Honor, if I may point out that you'll see in item 4, it says that clearly that
I'm reading it.
the company owns any creative contribution made by the artist within the time period and duration of the contract.
Judge Mablean's verdict when Justice with Judge Mablean returns. You're watching Justice with Judge Mablean.
You're entitled to the royalties. You know what I suggest? You hire a lawyer. You make sure you track it when the song is released. And somebody else sings it, no matter who. But you need to get a lawyer right now
Okay.
to protect your interests that you didn't do before. You can't have this man being your producer, your co-writer, your lover, all of that. It creates problems. Okay, if you're going to be in this business, go somewhere to the library, get you some books, read, understand, find out how it works. Most of all, get you a good lawyer who understands and knows the business, and then listen to that person, all right, and follow their instructions. At this point, you're not entitled to anything until such time as the song is recorded and released, then you're entitled. So, judgment for the defendant.
Judge Mablean has ruled in favor of the defendant. The plaintiff's claim has been dismissed.
You're a cheating hound, and I'm never writing another song with you ever again.
Well, that's too bad because we make beautiful music together and you owe me another record.
This has been a production of Entertainment.